Hi, I'm Randy Guy, Commissioner President of St. Mary's County, Maryland, and you're tuned in to MACO's Conduit Street Podcast. Whether you're a Maryland resident, a government official, or just someone interested in learning more about public policy in Maryland, this podcast is for you.
Welcome to the Conduit Street Podcast. This is Michael Sanderson taking the chair once again. It's my privilege to host this podcast episode with my colleague at MACO, Sarah Sample. Sarah, welcome.
Hello, good morning.
So, Sarah, one of the things that you work on as part of your MACO portfolio are legal issues. You work with our county attorneys, and we thought today's episode would be a chance to spotlight something that we haven't really talked about on the podcast before, I don't think, and that is from time to time, MACO plays a role in an ongoing court case by filing a brief, of sort of a friend of the court brief, and advocating on behalf of county governments and the services they provide. It's another part of what MACO does as advocacy on behalf of our county services. So there's one of those cases is afoot right now. Sarah, you wrote a piece on the Conduit Street blog this week talking about the case. We wanted to dig into it on the podcast with our guest. He's a deputy county attorney in Arundel County, Hamilton Tyler. Hamilton, thanks so much for joining us.
Certainly. My pleasure joining you all.
Great. And so before we dive into the details of the case that we're going to be discussing, go ahead and tell us a little bit about your time with Arundel County and sort of what brought you into this work. How long have you been there? Do you like it?
Sure. Yeah. No, I love it here. I have been with the Office of Law for Arundel County for 25 years now. I practiced briefly in Baltimore, well, not briefly, for 9 years in Baltimore, doing insurance defense work before coming here in the year 2000, where I was mostly doing litigation, defending the county when they get sued. I did that for a good long time, and we also do advice to all the departments to try and keep from getting sued as well. About 10 years ago, in January of 2015, I was named one of two deputy county attorneys, and I've been in that role pretty much ever since.
So for our listeners, Ham, if you could, like, just the nuts and bolts of the county office of law, the general function. You mentioned you give advice and guidance to entities within county government. Can you lay out a little further of what the county office of law generally does? It might not be as obvious as maybe, the health officer or somebody like the park and rec director.
Certainly. So the Office of Law does all the civil work for the Anne Arundel County government. Mm-hmm. So we do not do any prosecuting. That's the Office of State's Attorney. So we provide advice to all the departments. Several attorneys do just litigation because the county is self-insured, so it doesn't have insurance for liability. So it puts all the money in one pot and then pulls from that pot when claims are paid. In connection with that, 6 or 7 attorneys defend those cases as they come in. The office also handles different things like code violations, land use issues. We review over 4,000 contracts a year, which is required by county code. Handle child in need of assistance cases for Department of Social Services. So it's a pretty wide-ranging practice in which 23 attorneys work full-time to do everything the county wants to do. So we try to we really do minimize the use of outside counsel in terms of defending the county and giving the county services.
Got it. So one difference that you mentioned there is Anne Arundel is a large enough jurisdiction to basically self-insure. So if the county is a defendant in a suit, the Office of Law would defend and represent the county government's interest in that proceeding. That might be different from some of our smaller jurisdictions and from our cities and towns who probably aren't large enough to self-insure. A lot of them get insurance coverage either through the local government insurance trust or on the private market. They might have an insurance policy, and that might change the nature of them defending claims against the county. But for a self-insured jurisdiction, you're front and center. Got it.
Correct. So when you hear about a verdict, if we do, in some cases we do settle cases or we get a verdict, that money being paid is taxpayer money.
Yeah, so the case we're going to talk about a little bit today has to do with the opioid crisis. So Michael referenced the blog that I wrote, so there's more information there for our audience members. But so it's mainly focusing on the ongoing cost of remediation, but also the damages of some of the damage of the crisis overall, and what's sort of required of counties in terms of that remediation. I mean, I know just from my time with the Human Health and Human Services portfolio and the government liability portfolio that we've got law enforcement, local health departments, human service divisions, social service divisions, our detention centers. There is a touch point for so many different county divisions when it comes to remediation of the opioid crisis. So maybe tell us a little bit before we get into the case, just about opioid crisis remediation efforts in Anne Arundel County, to sort of like ground us in the reality before we get into the legal procedures. So like, what does some of the harm and remediation look like there for you guys?
Sure. So for the damages has been just catastrophic. Since they began keeping track of it in 2017, there have been over 700 fatal overdoses just in Anne Arundel County. Those have affected not only the families, affected the families a great deal, particularly the children. And it's estimated that between 40 and 75 children per year in Anne Arundel County have been impacted by the loss of a parent from one of those overdoses. Another issue is the loss of productivity due to opioid use disorder that results in county residents not being able to work and contribute to the economy and the community. In 2019, there was a survey by the National Safety Council that estimated that 75% of U.S. employers have been directly affected by opioids. And then in terms of the criminal justice system, there are higher rates of criminal justice system involvement and increased health costs also factor into the impact of opioid use disorder in the community. From 2020 to 2024, there were 4,400 emergency medical services calls for opioid-related overdoses in Anne Arundel County. And when you think about it, that's a huge number and a cost of police, fire, all public safety, and then not to mention the strain on the healthcare resources for emergency department visits who have to deal with those issues.
Yeah, it's certainly been overwhelming. I mean, some of those numbers just for Anne Arundel County that we've had, thousands of casualties it's overwhelming. It's overwhelming at all those levels. And so I think that sets things up for the issue of the moment is that some of this fight as a matter of public policy has gone to the courts, trying to impose liability on the manufacturers and distributors of these various opioid products, particularly when they may have advanced their product without making it clear the potential for users to become addicted and become dependent. I think that's the lay and shorthand version of this argument, that there's some liability on those entities who made money off this trade. And we've been in the middle of that fight for some time. We've had some judgments and a national settlement with a number of players. But the legal side of this is going on, and that's what brings us to the case at hand. Is that a fair setup?
Correct. Yes.
Okay.
The first lawsuits were filed back in, actually, Anne Arundel County was the first jurisdiction in Maryland to file a lawsuit against the opioid manufacturers and distributors in January of 2018. And it named all the major players at that time. And Anne Arundel County is represented by national outside counsel. It's the magnitude of that initial lawsuit that was filed was so enormous that the Office of Law, even with 23 attorneys, could not deal with it. It would shut down everything else we did. So we partnered with the firm, large national firm with 100 attorneys, and they devoted incredible resources and incredible expenses to that lawsuit and prosecuting that. So initially, that suit was filed. It was in the Circuit Court for Anne Arundel County. It was one of the few lawsuits that was actually not transferred to the multi-district litigation in federal court in Ohio. And so what court
That's
systems...
what I was wondering about. Yeah.
Yeah, so what court systems do when they get a lot of lawsuits in federal court, they put them all in one place, basically. And we discussed it with our outside counsel, and we didn't want to be in that lawsuit. We wanted to we wanted to maintain our own claims that were specific to Anne Arundel County and try our case here. Now, ultimately, things got slowed down. The case in the federal court in Ohio proceeded and has been proceeding for a long time. Michael mentioned settlements. There have been a number of settlements. The major players have mostly settled in terms of the manufacturers and distributors. And in fact, Anne Arundel County is receiving monies from those settlements. We've gotten almost over $14 million in so far, and we will continue to receive monies for the next 12 or 13 years based on those settlements.
And so your case, the one that we're going to be talking about today, that one, because it's different defendants, that's why this one's able to go forward, even though a lot of people participated in those other larger national settlements?
Correct. So the case we're talking about today is a separate case that Anne Arundel County filed, also using national outside counsel, against the pharmacy benefit managers. And those are the companies that basically act as middlemen between companies and the manufacturers to set the formularies of drugs that are provided under prescription plans. And so a company may go to Optum or Express Scripts or CVS Caremark are the three major ones that are responsible for probably 90% of the contracts. So Optum will negotiate with, they were negotiating with Purdue Pharma, who was the worst actor of any of these defendants. Mm-hmm. And they would make deals with them so that OxyContin was placed on the formulary list at a very high level, high meaning easier to get, in exchange for monies paid from Purdue back to Optum. And for every sale that was made, one of these pharmacy benefit managers received some compensation for that, separate and apart from what the actual user paid for that. So the Anne Arundel County filed suit against these pharmacy benefit managers about 2 years ago. It was initially filed in circuit court. They removed it to federal court in Baltimore, which they have the option to do if they're out of state. They did that. And what Anne Arundel County is alleging, that this collusion with manufacturers to increase opioid sales by giving opioids preferred placement on formularies without putting in place limitations on their use. Mm-hmm. And they did this obviously in exchange for rebates and fees. And there were other agreements, parts of the agreement, which were also problematic. And some rebate agreements required patients to be able to get 320 milligrams of OxyContin a day without prior authorization. Well, that's a huge amount. Mm-hmm. The typical post-surgical doses are 10 milligram pills every 2 to 4 hours. And so this was putting a lot of opioids out there.
Yeah, I mean, that's a staggering, like that particular example is just staggering. That's a really big number, that like the equivalent of dozens of individual doses becoming a prescription for an individual. It just seems like a recipe for trouble, and it seems like the kind of behavior that would bring you into court, right?
So tell us a little bit so you file in the federal district court, and I think it was like the same day, there were a handful of different motions that were filed by the defendants, and one, if I remember correctly, was to dismiss the claims, and the other was a motion to certify questions to be addressed by the Supreme Court of Maryland with regards to the case. And I think it was Judge Maddox denied the motion to dismiss, but did grant the motion for questions. So essentially, he stayed the case until the Maryland Supreme Court would weigh in. So can you tell us a little bit about the memorandum from Judge Maddox and what he was sort of saying in that decision?
Sure. So once the case was filed, all the defendants, there were more than three, filed motions to dismiss, which is fairly typical. And those motions to dismiss are saying, in essence, even if all the things that are true in the complaint, assuming just for the sake of the motion, those things are true, the county shouldn't recover anything because X, Y, and Z, because of the legal issues. And so they filed those motions. And at the same time, they also filed a motion to certify questions to the Maryland Supreme Court. And that is a procedure. It's not done a whole bunch in federal court.
I was wondering about that because that was the first time I'd seen it.
Sure. And it's only used when the federal court isn't quite sure what a Maryland court would do, because federal courts apply the law unless it's a truly federal claim, a federal civil rights claim under 42 U.S.C. Section 1983, or some other uniquely federal claim. The federal courts are applying state law. So in this case, the issue is public nuisance. And that was the only count filed by the county in the case. So public nuisance is defined as an unreasonable interference with a right in common to the general public, or another way to define it is conduct that involves a significant interference with the public health, the public safety, the public peace, public comfort, or public convenience that can give rise to a public nuisance. So in this case, the county's saying the actions by the pharmacy benefit managers and also the pharmacy, the different pharmacies associated with those benefit managers, which use mail order, and then also CVS has their standalone pharmacies within the county. Those contributed to the opioid crisis, which we contend is a public nuisance under Maryland law. So then the court started looking at it and needed to determine, well, what would Maryland courts do? Well, this situation involving public nuisance and an actual crisis like the opioid crisis is somewhat unique and hasn't fully been addressed by the highest court of Maryland, the Maryland Supreme Court. So when that situation happens, the federal court can basically ask the Maryland Supreme Court questions, certified questions, and that's what it did in this case.
So the case is in federal court, but because the merits of the case hinge on a proper interpretation of Maryland state law, they've basically handed a component of this. They're looking for input from the Maryland courts on the proper interpretation of, I guess it's Maryland laws around nuisances. Is that fair enough?
That is correct. Yes. So basically the federal court said, all right, I'm not going to grant these motions to dismiss now. I'm going to deny them without prejudice, meaning that they can be reconsidered, and the case is going to be stayed, and the case will stop while the Maryland Supreme Court decides these two questions that we're going to send it. And then once the Supreme Court decides those two questions, we'll get the answers, and then we'll decide these motions to dismiss and the rest of the case. Right. So it sent two questions to the Supreme Court. The first question, under Maryland's common law, can the license dispensing of or administration of benefit plans for a controlled substance constitute an actionable public nuisance? And the second question, if so, what are the elements of such a public nuisance claim, and what types of potential relief can a local government plaintiff seek when asserting such a claim?
Okay, so that gives us a little clearer handle on the questions that are now before the Maryland courts. And I guess in practice, what a good deal of this comes down to is, I think a lot of activities around public nuisances involve property, right? I'm thinking of the case where someone has let their land kind of be untended, and now there's standing water, and the water has become septic, and there's mosquitoes and bugs all around the water. It's becoming a neighborhood effect beyond just the landowner. So you might say, as a matter of public health, you can declare that to be a public nuisance and require that they clean it up, or you come in and do it and you bill for it or something along those lines. But those easy to think of examples of public nuisances tend to involve property. And here we've got something different. It's about a product being made available for sale in a variety of ways. That's different than this particular plot of land or this building or the like. And that, I guess, is to some degree, that's the heart of the question, right?
Correct. That's exactly the heart of the question. And the courts have found, and you mentioned the one example. Another example is a particularly noxious dump that's putting off fumes and bad smells in an area that affects just a myriad of people all around, things like that. And the Supreme Court's has not yet come down on the situation with the opioid crisis. However, since 2018, courts in at least 22 other states have recognized public nuisance claims in opioid litigation and rejected the claims that public nuisance is limited to claims arising just out of the use of the property. In fact, that was the basis. Public nuisance was the basis for the huge national settlement between the three major distributors and Johnson & Johnson that resulted in $50 billion being distributed nationally. And that's where a fair amount of the county's money that it's receiving, has received already and will continue to receive, is from that national settlement. So, and that was based primarily on the federal multi-district litigation in Ohio, acknowledging that public nuisance was applicable in these circumstances.
Yeah, and wasn't there a case in Alaska that also, I mean, as far to the first question about whether or not the sale of a lawful product could constitute a public nuisance, I think in Alaska they already said that it could in a federal court.
Yes, Alaska, Washington, and as I said, 22 other states, and those federal courts are applying state law when they make those when they issue those decisions. So the vast majority of state courts and federal courts applying state law that have considered the issue have determined that public nuisance does apply to the opioid crisis.
So then the next step, I guess we've got, what is the date? It's going to be September 9th is the hearing when they have the oral arguments in the Maryland Supreme Court?
Correct.
Yeah, what's going to happen that day? What do you sort of anticipate it's going to play out?
So what's happened already in the Supreme Court is that briefs have been filed. Both first Anne Arundel County filed their brief, and the pharmacy benefit managers filed their brief. In addition, as you mentioned before, MACO and the Maryland Municipal League filed an amicus brief, a friend of a court brief, advocating for Anne Arundel County's position. There have been numerous friend of the court briefs filed from all sorts of different national organizations, both on behalf of the pharmacy benefit managers, through trade groups and industry affiliates, and then on behalf of Anne Arundel County by governmental kind of organizations. National Association of Counties is one that comes to mind. So all those groups have filed briefs. I forget, I don't have the exact number. It's between 10 and 15, I believe, amicus briefs that are filed.
Full disclosure, I was going to try to read all of them before we had this podcast recording. And then when I saw how many there were, I was like, maybe not. It was a lot.
It is a handful. But in terms of the oral argument, only the parties get to argue in the Supreme Court. So on September 9th, the hearing will be approximately an hour, and it's before the members of the Supreme Court. And there are basically, each side gets 30 minutes to argue. And so the attorneys have 30 minutes to make their case. Often the oral argument is mostly about questions from the bench, from the Supreme Court justices. And you get, I've argued once in the Supreme Court and many times in the lower court, the appellate court of Maryland. And you prepare this argument to go 30 minutes, but oftentimes you get into about 1 or 2 minutes and then boom, you start getting hit with questions left and right. And that's the most important part of it, is answering the questions, because these are the judges that are going to decide the case, and their questions are focused on what the salient points of the case are. So it's really important to listen to those questions. And full disclosure, I'm not arguing. The National Counsel is the one that's going to be arguing the case. I'll be there, but I'll be cheering them on.
And so the attorneys on behalf of the companies that Express Scripts and the other players in this case, they're going to try and make an argument that there are some facets of Maryland law that should lead our state to conclude differently than some other states have about the application of this nuisance concept to non-property claims. That's the central question, but they're going to try and say Maryland has different facets in its own, I guess, in Maryland common law, and that's why you should rule differently than they did in Alaska or Washington State or other places. That's essentially the heart of the argument. Maryland's different, and here's why.
Correct, and they're gonna make that argument. Then they're also gonna make the argument, if it isn't different, it should be. You know,
Right.
Supreme Court makes Maryland law, and so they will argue that Maryland law should be defined. Public nuisance should be associated with the property, and to the extent that it's not that way already, it should be in the future. And this case should be the one to make it that way.
And so from the perspective back to all the remediation efforts and the care of our neighbors and friends in the community who have faced these crises, who've lost a loved one or are in treatment and so forth, those resources may depend on this kind of litigation. It's become a primary way to help support the services that our neighbors need. So that's really what's at stake. The ability to, it's not polluter pays, but it's sort of the party who created substantially this problem that has swept over Anne Arundel County and most of America in such a violent way, that they ought to be contributing toward the ongoing efforts to help heal and recover from all this damage. In the event that the Maryland courts find that this legal theory doesn't apply here, it sounds like that would jeopardize this case pretty gravely, right?
It would. And let me speak to the county remediation efforts a little bit as well. And you mentioned that, it's been huge, the amount of money and effort that has been spent over, since like 2015, 2016. And at that point, the county had a task force of each county agency to address what each department could do to prevent deaths and promote well-being of folks. And the police started carrying naloxone back then. The emergency medical services would leave behind naloxone. They implemented safe stations where residents could go to a police or fire station and ask for assistance getting to treatment, turn over any illegal substances they have for the police to destroy. The health department created 24/7 treatment on demand. There was the creation of an opioid dashboard to track incidents in the county to inform kind of where these issues were happening and to put resources in those areas. There was an overdose response program that the health department created. Overdose survivors outreach services team was created, which is part of the Department of Health, and attempts to contact 100% of all known non-fatal overdose survivors. Some of the newer efforts that are ongoing are naloxone vending machines at locations around the county, a harm reduction advisory committee, which includes all stakeholders to inform interventions and services, and then media campaigns to address the stigma of substance use. And this stuff these processes have been working. Non-fatal overdoses are down 67% from 2017 to 2024. Fatal overdoses are down 44% from 2017 to 2024. And opioid-related emergency department visits have decreased by 48% in 2024. So we're making progress, but it's not gone. There are still overdoses occurring, and it's going to take a long time to really work through everything.
Right. The needs for these services are not hypothetical. This is a reality that local governments are on the front line of facing this. We see it in our clinics. We see it in our local detention centers. It's part of fire and emergency services and so forth. It's just everywhere. So it's not like we're sitting around dreaming of wonderful things we might be able to do if we got some money. We've got to do this stuff, and these resources are needed.
Yeah, and Michael, to your point about the detention centers, the medication-assisted treatment programs that are required in all the detention centers, annually, we're looking statewide at $15 to $20 million a year for the cost of those programs. And especially with medication-assisted treatment, like when it comes to how long-term that treatment has to be, there's a lot of debate in the medical field about whether or not an individual who was, did have an opioid use disorder and was using pretty habitually, the chemical damage done to the brain, there's a lot of debate as to whether or not it can be reversed even with the medication-assisted treatment. So there's potential that people would be on it significantly longer than like 6 months to a year is what some people had initially thought.
Okay, so Ham, you mentioned the second question, sort of asking the Maryland courts to lay out like what are the elements here. So can you explain like what happens on that question if we get a favorable ruling on the first question, where the courts say yes, we think something of this nature can be a subject of Maryland nuisance law? What's the second question? It's a little tougher for me to grasp that. Can you lay that out a little for us?
Certainly. The second question was, what are the elements of a public nuisance claim, and what types of potential relief can a local government plaintiff seek when asserting such a claim? So if the court determines that Maryland's common law does allow for an action for public nuisance under this, it's going to set out the elements. And I think that the federal court's asking for kind of a roadmap on kind of what these elements are. Are they, and we talked a little bit about that before, in the definition of what is a nuisance, unreasonable interference with a right in common to the general public. I think the federal court's looking for a little tighter definition than is currently in the case law, because this is all case law. There's no statute or law that says this. It's just case law that's evolved over 100 years in Maryland. And so that's what they're looking for in that second question. And then what types of relief can a local government plaintiff get? We're looking for our past expenses that we spent in fighting the opioid crisis. And then we're also looking for monies for abatement. And abatement is, going forward, what we want to do in the future, and much of which we're already doing, but we want to continue to do it. And maybe there's some other things we can do if we have more money to help address the problem going forward.
And can I ask, so when it comes to the first question, which I know some of in what Anne Arundel County had filed, the need for answering the first question, you guys had made the argument that it's not there, and you guys had cited 4 separate cases, I want to say, that make clear that this constitutes a public nuisance. So are you surprised that they're needing to answer that question based on what you guys cited in your research?
Not totally. It's a somewhat unique situation because we talked about the examples before where, those were things you could touch or smell or hear, loud sounds, smells, things that affected people right around the areas where the actual things occurred, a leaking underground gas tank. But the dispensing of opioids and opioids are legal. They're a legal drug. The problem is they were being misused and overprescribed. So that's been somewhat unique since the opioid litigation started, the last 11, 12 years. So it is a somewhat novel issue for Maryland. So it doesn't surprise me that this occurred.
Okay, so arguments are coming up soon. How long is it likely to take the Maryland courts to render their decision on this then?
It typically, for an appellate opinion, what they'll write an opinion on that. In this situation, it can be very involved, and that can involve going back and looking at all the other jurisdictions. A lot of times they'll look at, as I mentioned, 22 other jurisdictions have already decided this. They will go through and look at those and analyze those cases. So the opinion can be very involved and typically takes, for the Supreme Court, between 6 and 12 months. It can be a little less, can be a little more, but that's typically what it is.
Okay, well, a lot is at stake here. I think, we've talked a good deal about how severe the opioid crisis has been and continues to be across our communities. So we've got a big stake in the courts hopefully getting this right and letting this case proceed, with that guidance from the state of Maryland. Ham, thanks so much for joining us today and sort of bringing our listeners up to date on an interesting issue. And even though like some of these questions are technical and legal, I think you can kind of understand why we're in the middle of this. Why would Mako join and submit a friend of the court brief trying to argue to help guide the court make a decision in our favor? Because it seems like we're on the right side of this one, I feel.
We are, and it's not just this case that's at issue. The implications for this decision will filter into the future for all sorts of different cases. I mean, the importance of public nuisance cause of action to the opioid settlements cannot be understated. I mean, that was the basis for those cases. The affirmative litigation process for local governments, nationally and in Maryland, has been increasing a lot, and many of the bases are public nuisance. So we want the public nuisance claims to be available in the future in Maryland, so that we can pursue that. If other issues occur that are affecting our county residents, we want that tool in our toolbox, and this case will decide whether it will be there for us.
Right. The one that comes to mind pretty readily is we're already seeing litigation starting to bubble up around these so-called forever chemicals, the PFAS, and that being potentially a pollutant in our water systems and in our landfills and other places like that. That may be another case where maybe there was corporate behavior that led to this crisis. And if we don't have a public nuisance law as a foundation to make the polluter pay, we may end up, this will be borne by taxpayers rather than the companies who profited. So yeah, there's ripple effects from this case, even though this one is about the opioids. It's more about, is this tool going to be available under Maryland law?
Correct. We want it going forward.
Right. Very good. Well, let's leave it there for this episode. Thanks very much for joining us, Hamilton. Thanks, Sarah, for leading the way and doing some digging into this topic, and for the write-up on the blog. We will link to that in the show notes for this episode. As always, if you enjoy the Conduit Street Podcast, make sure you subscribe and go ahead and hit that 5-star review. You know you want to, and that's the best way to let other folks know what they've been missing out on. So on behalf of Hamilton Tyler and Sarah Sample, this is Michael Sanderson. We will talk to you soon.